Hello, good morning, everyone. My name is Kriti, and I'm a first year law student at Jindal Global Law
And I'm
School.
Aaron, and I'm also a first year law student at JGU Global Law School.
We are interns at Asha Infinite Foundation, and we will be conducting today's workshop on medical negligence. I would like to inform everyone that all the content you see on your screen has been created and put together by Outlawed India. So these are all the topics that we will be covering today. Basically, this workshop will be a very insightful overview as to what medical negligence is in the context of India. So we all know what the common definition of negligence is, but the definition that we use in our everyday spoken language is different from the legal definition of negligence. The term medical negligence is not written anywhere in Indian law, but has an accepted definition, and it is essential that we understand and stick to this definition throughout the course of today's workshop. So it's written right here. Medical negligence can be defined as the failure of a medical practitioner to provide proper care and attention and exercise those skills which a prudent, qualified person would do under similar circumstances. Now, when I say medical practitioner, I do not specifically talk about doctors, but also nurses and chemists as well. So, throughout the course of today's workshop, when I say a medical practitioner or even a doctor, I'm just talking about the professionals involved in the medical field. So, coming to the scope of negligence, let's start with discussing about the doctor-patient relationship. So, when you go to a doctor, we know that this person possesses the expertise acquired through years of studying and practice. We have a certain level of confidence that they would provide an expert solutions to the problem we have. Hence, this relationship is fiduciary. That means that it is based on trust. This trust that the patient places on the doctor is paramount, and as the patient's health is linked to it. Therefore, the doctor owes a duty of care towards their patient by undertaking a case, treatment, by deciding the treatment to be followed, administration of that treatment, accepting a patient within their expertise, exercising a reasonable degree of skill, taking a reasonable degree of care. Now, coming to the relationship between breach and injury. So, for medical negligence to be proved, there needs to be a link in between the breach of duty of care by the doctor and the injury faced by, or injury or harm faced by the patient. This link can be direct or even proximate. So, when I say direct, I mean the breach or the negligent act of the doctor is directly linked to the injury faced by the patient. Basic example would be that the doctor was supposed to perform surgery on the right hand, but instead he or she does on the left hand. So this negligent act of the doctor causes harm to the patient. Therefore, the link is direct. But when it comes to proximate, I will be explaining that with the help of this example here. So, a patient with about 50% burns died 40 days after the date of a wrong blood type transfusion. Medical negligence could not be escaped as causal relation between the transfusion of the wrong blood type and death was proximate. So, the defense might argue that the patient already had severe burns and that could have caused the patient's death. But at the same time, we all know for a fact that transfusion of the wrong blood type is not only fatal but is life threatening as well and has a huge possibility of directly linking to the patient's death. Therefore, it might not be a direct link, but it is a link close to the patient's death. That's why we would consider both direct as well as proximate when it comes to medical negligence. So how do we know if the treatment we are given is sufficient or not? As discussed earlier, a professional is someone who has specialized knowledge and skill. So when we go to a doctor, we trust them that they would bring a reasonable degree of skill and knowledge and they would also exercise a reasonable degree of care. Hence, when we go to a doctor, we do not expect them to perform a very high level of knowledge of a certain subject, but just the minimum standard of care is enough for the doctor to be practicing. So, for example, it is a compulsory protocol that doctors must take the medical history of a patient before prescribing any drugs. So, when, say, a doctor fails to do that and just prescribes a drug without taking the medical history, then he is not performing his profession within the minimum standard of care, but is below the minimum standard of care. And this amounts to medical negligence. And this minimum standard of care is the accepted standard of care by the medical community as a whole. So how do we know if the medical practitioner would take the required care? An implied undertaking of the medical profession is when you go to a medical practitioner and they provide you with the specific advice or treatment. So basically, when they do so, they are implying that they have this required set of skill and knowledge to do so. And it can also be viewed as an indirect promise of adhering to the minimum standard of care. So basically, medical negligence could be considered when a doctor's practice deviates from the minimum standard of care, or his action or practice is below the minimum standard of care. We have already established that the standard of practice is what is accepted by the medical community as a whole. And that is why it is called practicing medicine, because there are constantly new discoveries and rejections of old ideas that keep taking place in the medical profession. And standard practice of what we see is constantly evolving. Therefore, it is of utmost importance that doctors keep themselves updated with what is the current trend in the medical field, what practice is irrelevant, what practice is being adopted, which has much more efficient care. Hence, the accepted standard of care would be the medical community's consensus at that particular time. So while keeping in mind the minimum standard of care, the court needs to also consider the body of knowledge and equipment available at the time of the incident. For example, we already spoke about how the medical field is constantly evolving in terms of what should be the accepted standard of care. So the court should take into perspective what at that point of time when the incident occurred was the body of knowledge of what should the protocol be. And also this can be applied to equipment as well. Now, we cannot expect every single hospital to possess really expensive, high quality equipment. All they have to do is have the equipment, the minimum equipment needed for the proper administration of treatment to the patient. And there is a case which I would like to explain here. So there is a case where a patient went with like artery problems, went to an hospital A, and over there was no mechanical ventilator, and that's why the patient had to be transferred to another hospital B, because of which there was a delay in treatment and the patient suffered serious injuries. So here, hospital A would be held liable because they did not have the minimum standard of care of having this mechanical ventilator. And that's why they will be held liable for medical negligence. Now, how do we prove the minimum standard of care at court? This is done with the help of the Bolum test. This test is used specifically in fields where professional skill is involved. The medical field, being a professional field, enables us to use the Bolum's test here. The test puts forth that the medical practitioner need not need a really high level of skill or extraordinary talent, just the reasonable skill that an average practitioner in the same field would also possess. So to prove this, an opinion of a credible practitioner in the field who specializes in the same area will be taken to see if the doctor in question has adhered to what the minimum standard of care is. So if a doctor follows the minimum standard of care, if he follows all the protocol that any other practitioner would follow, then he wouldn't be held liable for negligence, even if there is an error. As long as he's followed the protocol, he's followed what would be the minimum standard of care, he will not be held liable. Let me ask all of you a question. So say there is a case and there is a medical negligence on part of the doctor, and the doctor side provides with a very credible opinion saying that all the treatment and the practice provided by the doctor was within the minimum standard of care, and there was no negligent behavior on behalf of him. On the other hand, the patient also provides with a very credible opinion that the doctor was negligent on his behalf and did not adhere to the minimum standard of care. So, what decision do you think, and whose side do you think the court will side in? So here, the doctor will not be held liable as they have an opinion in their favor, which proves that this particular practice is accepted to a certain level. Even though this is a very debatable stance, there are still a lot of factors that the court will take in and then pass a judgment in such a situation.
Now we'll talk about the two types of liabilities for medical negligence cases. Okay, the two types of liabilities are like civil liability and the criminal liability. Okay, there's a significant difference between them. So civil liability comes into play when the objective of the aggrieved party is to gain monetary compensation. In these cases of civil liability, the injury is usually not that grave. And for civil liability cases, the courts you can approach is basically the civil court and the consumer forums. The Lok Adalat is also another court you can approach for this. So, okay, there's a difference between Lok Adalat and normal civil court. So the difference is basically the Lok Adalat, so they have a discussions and they reach a settlement. So they're trying to achieve is a peaceful solution. There are no lawyers arguing each side and judge making a decision. So they're trying to achieve a peaceful solution. So if they can't achieve a peaceful solution, then they move on to the higher courts. So now we look at a important court ruling which helps understand in which type of situation can doctor be held liable for medical negligence cases. So this is a Supreme Court ruling, so it has a very high binding power. So it was held that if a doctor follows procedure which is determined to be proper by a reasonable body of medical professionals, then he will not be held liable just because something went wrong. And if the doctor has adopted a course of treatment which is suitable for the patient and has exercised an ordinary degree of care, the doctor cannot be held liable if the patient is not cured. So, what the ruling is trying to establish is that perfection is not expected, and what they really expect is not any degree of care. So, yeah, so in these, I've talked about a reasonable body of medical professionals here. So, basically, in these cases, the reasonable body of medical professional is like expert witnesses, and these expert witnesses in medical negligence cases are like medical established medical professionals. So now we shall look at some conditions which should be satisfied before the liability can be considered. Firstly, there must be an act of omission or commission by the accused party, and this act must be in violation of the duty of care owed by the doctor to the patient. And also, this act must be directly or indirectly result in an injury to the patient. So basically, the negligent act of the doctor must have a link to the injury sustained by the patient. Here you see, first there has to be an act of omission or commission, and this must be in breach of the patient's duty, doctor's duty, and this must have caused harm to the person. And the harm to the body, so there must be a link, there must be a proximate link as we have discussed earlier. So now we'll see how exactly they provide proof for cases of medical negligence. Okay, firstly, we can use you can cite best available medical evidence and use the testimony of the expert witness. Another important principle you can use is that of the res ipsa loquitur. So what this says, so it's a Latin term and might seem a little complicated, but what it means is that the thing speaks for itself. This can be used in cases where the occurrence of the accident was unexpected and it could not have occurred if the doctor was not negligent. For example, after surgery, a piece of surgical equipment is found in the body of the patient. So this itself will be a proof of the negligent act. So we see that the principle can be applied because the finding of the surgical equipment is itself a proof of negligence. So hence the doctor can be held liable for negligence in this case. Now I also mentioned that consumer forum is also a court we can approach for civil liability cases. So this is because medical services is also considered as a service under the Consumer Protection Act. So can anyone think of a situation in which a medical service will not be considered as a service? So if a medical service is a free medical service, then it will not be considered as a service, because for it to be considered as a service, there has to be some sort of payment, be it partly paid or fully paid. So what they're telling is that if case of if the doctor is negligent while performing a free medical service, then he cannot be held liable in consumer courts. But still, you can apply civil and criminal liabilities here, and you can approach civil courts and criminal courts. Now we'll move on to the criminal liability cases. Okay, so what exactly is the difference between civil liability and criminal liability cases? Civil liability is for cases of civil wrongs where the crimes are like against a person. So, and criminal liabilities for criminal acts which can be considered as a crime against the society as a whole. So that's basically the difference. So in case of medical negligence, the doctor can face criminal sanctions in cases where the negligence is of such a high degree that it can be considered that the doctor acted with disregard to the life and safety of his patient. This disregard of life is seen as a crime against society as a whole. So the criminal liability for medical negligence is addressed in section 304A of the IPC. And this states that whoever causes death of the person by a rash or a negligent act not amounting to culpable homicide shall be punished with an imprisonment of a term of 2 years, or with a fine, or with both. So we see that if there was an act which was of a high degree of negligence, and this act resulted in the death of the patient, this can result in an imprisonment sentence of 2 years. So here I use the term high degree of negligence. This is just another word for gross negligence. See, although gross negligence is not mentioned in the IPC, but the courts look for gross negligence in the cases of criminal liability. Okay, yeah. So first, what they need to establish is that the three conditions for negligence must be established. Then after that, they look for gross negligence in case of criminal liability. Okay, so in these cases, the doctor undertakes an action which he knows can most likely result in an injury, but he goes ahead and that action results in an injury. So there aren't any written rules as what should be considered as gross negligence and also, but the doctor decides this on basis of the facts of the case and using the Bolum's test and all other factors are also relevant in this part. And so mere errors of judgment do not imply negligence. Okay, so yeah, here are some examples of gross negligence. Like you see the removal of the wrong limb, uh, using a wrong drug or gas during anesthetic process, and not being qualified, and but still performing a certain procedure. So here were some examples. We'll look at the uh, important other relevant sections of the IPC, which deal with medical negligence. Okay, so section 304A was for death, and so section 320 and 323 is for hurt cases. Okay, so here's an important thing you must know in this thing. So if the doctor is found guilty of negligence in the civil court, this does not act as proof of guilt in criminal court, since the negligence can be of a degree which does not amount to gross negligence. So what they're trying to say is that if the doctor is found guilty in civil court, this does not automatically mean he'll be found guilty of negligence in a criminal court. Okay, now we'll look at some defenses against medical negligence. Okay, so first there's a section 80 of the IPC. So this can be applied if there was no criminal intention or knowledge of the act, and the act was a lawful act conducted in a lawful manner, and proper care and caution was taken. There's also the section 88, and this can be applied if the act was done in good faith for the benefit of the patient and was done with the consent of the patient. So here we saw the importance of consent. If a patient is operated on without their informed consent, the doctor can still be held liable for medical negligence. This shows us that the patient has the right to refuse treatment, even if the refusal is considered to be foolish. And even in these cases, the doctor cannot impose his will. For example, if the doctor forces the patient to undergo treatment, he'll still be held liable for medical negligence. Okay, but here the doctor can act on substituted consent when primary consent is not available. So this applies in cases of minors where the parent can consent to treatment, or in cases where like the patient is unconscious or mentally unsound. Okay, so here is a question. So there was a 44-year-old patient. Yeah, you can read this. Yeah, so basically there's a 44-year-old patient and she consented to a laparoscopic test. So when the patient was under anesthesia, with the consent of the mother, an additional procedure was carried out. But after the thing, the patient sued the doctor for negligence. So will the doctor be held liable for medical negligence? Here, I think the answer is yes. So in this case, you see that the patient is 44 years old and consent was only given for the laparoscopic examination. There's no there was no consent given for the additional procedure. So, but although the consent was obtained from the mother, but since the patient is a 44-year-old and the patient's life was not in an immediate threat, so they cannot use that as consent. So that's basically what this says. This question was based on a real life case of Samaira Kohli versus Dr. Prabha Manchanda. So what the court stated was that if the consent was given for a particular operation, does not mean that this consent given for additional procedure, even if this procedure was for the benefit of the patient. And even if this procedure helped to prevent like any cases of danger in the future. So unless there was an immediate threat to the life of the patient, the doctor will not be authorized to carry out any additional procedures. Here we saw that without informed consent, the doctor can still be held liable for negligence. What exactly is informed consent? Informed consent is basically a real and valid consent. So the doctor must obtain this before proceeding in anything. So to obtain this, what they must do is that provide adequate information which is necessary for the patient to make sensible judgments. So this does not mean that the doctor should discuss all the possibilities. Only a remote possibility should be, no, not even remote possibilities should be discussed. Only information which is required to make a decision should be provided. Okay, and now you may question that how do we know the information provided to us adequate? So this will be determined by a reasonable body, medical professionals.
Yeah, so the Indian legal system understands the complexity of the medical field and so has given a certain degree of leeway when it comes to the judgment of doctors during any treatment. But at the same time, it also has provided some guidelines to be followed when it comes to medical negligence cases. Here are certain guidelines by the Supreme Court. First is that private complaints can only be filed in prima facie cases. So basically, prima facie is when it just means that at the face of it, or as soon as you look at the evidence is so credible and strong that it allows for the case to be filed. And this evidence is provided by a competent and doctor who has specialty in the same field and also provides credible opinion. Now, the second one is the investigating officer should provide and should conduct independent investigation with the help of a medical professional from the government service and who specializes in the same field and who would give impartial and unbiased opinion on the matter. And this is to obtain evidence for the Bolum's test. Now, the doctor should only be arrested if doctor would cause some sort of hindrance to the evidence and the doctor has a possibility of fleeing from wherever he has to. Okay, so this is the presentation and that was it. Thank you.